Hi, Attorney Joshua LeRoy here. Today we're talking about, can you get charged with DUI based on a drug usage? And the short answer in Florida is yes. DUI in Florida is not limited to alcohol. In Florida, DUI can be charged if the police believe that you are impaired by a controlled substance or alcohol. So for instance, marijuana, cocaine, even prescription medications, pain pills, can lead to DUI arrest and even a DUI conviction. The investigation is essentially the same between the two. The main difference between them is that if the officer believes that narcotics are used, drugs are used as the basis of the controlled substance, then following the arrest, the police are going to ask for a urine sample. And that urine sample will be obtained at the jail or at the testing facility, and it will be sent out for analysis. Depending on what comes back from that urine sample, a charge can follow and even a conviction can follow. The defense for a DUI based on a controlled substance is usually pretty similar to that of an alcohol-related DUI. We focus on the person's performance and appearance throughout the video and throughout the experience. However, the difference can be is that with a controlled substance DUI, defense can be that the person was taking their legally prescribed medication as prescribed and therefore should not and could not be charged with a DUI because their appearance was just the result of the medication that they were taking. Like any DUI analysis, we start at the beginning with the stop. We watched the videos, and we analyzed how the police treated the person. During a controlled substance DUI investigation, the question becomes, should I have submitted to a urine test following the DUI arrest? And the reality is that if you don't, they can suspend your driver's license for up to a year, just like with the breath test. Sometimes I'm asked, well, I did the breath test, and then they wanted a urine test, and at that point I had enough and I just said no to the urine test. Will I still lose my license? And the answer is yes. Florida law allows law enforcement to request a breath test and a urine test if they believe a controlled substance has been used or has led to the impairment. An analysis of the police report is essential to see if law enforcement actually had sufficient facts or sufficient evidence to support a belief that someone is under the influence of a controlled substance. At times on these cases, you'll see that the police will write a police report that says, I smelled alcohol, they appeared to be impaired by alcohol, his speech was slurred like alcohol, I found alcohol bottles or cans in the car. Then they provide a breath test to the person blows under the legal limit, at which point then the officer says, can I have a urine sample? Well, in that particular case, the argument is that, well, the officers thought it was a DUI related to alcohol. There was no reason to move on to a controlled substance investigation or to request a urine sample. There are numerous defenses, so please give me a call if you've been arrested with a DUI related to a controlled substance. I'd be happy to answer some questions and happy to discuss with you. Once again, it's Attorney Josh LeRoy. Look forward to hearing from you.